a simple garage addition in an exclusive neighborhood. I mean, sounds pretty straightforward, right? Well, in the community of Stone Canyon, it actually kicked off a legal firestorm. It pitted neighbor against neighbor and homeowners against their very own HOA. This is a story about how one project, and really one single word, could change absolutely everything.
See, at its heart, this isn't just about construction. It's really a story about language, about interpretation, and how one little word can have some seriously high-stakes consequences for a whole community. So that's the big question we're digging into here. We're going to follow the evidence, hear both sides of the story, and try to figure out how a simple home improvement project spiraled into a formal hearing in front of an administrative law judge. All right, so let's get right to the core of it. The whole conflict really got started when one set of homeowners filed a formal petition against their own homeowners association. So what happened was, the homeowners of Lot 20, Terry Marvin and Lori Lefferts, filed an official complaint, and it made a really serious claim that the HOA's own committee broke the rules when they gave the green light to their neighbor's construction on Lot 19. Now, to really get what's going on, we have to understand the specific language in the community's rulebook. The entire case, and I mean the entire case, really hinges on just a couple of key definitions. First up is the setback. The easiest way to think about it is as a mandatory buffer zone around a property. In Stone Canyon, the rules are clear that this area is supposed to stay as natural, undisturbed space. Next, we have something called secondary improvements. Now, these are things that are built on the property but aren't part of the main house itself. Like a driveway, landscaping, or walls to hide mechanical equipment. And trust me, this distinction, it becomes incredibly important a little later on. And this brings us to the two words at the absolute center of this legal fight. Understanding the difference between these two terms is literally the key to this whole dispute. So here's the crucial point. Both a variance and a modification can let you build inside that setback buffer zone. The thing is, they are approved through two completely different processes with very different requirements. Okay, just look at the difference here. A variance, that's a really big deal. It's a major exception, usually for the main house. You have to prove unreasonable hardship, and you have to get approval from the town first. A modification, on the other hand, is for those secondary improvements we just talked about. It's judged on a case-by-case basis, and you don't have to prove hardship. It is a much, much lower bar to clear. Okay, so now that we know the lingo, let's look at the evidence that the homeowners of Lot 20 brought to the table. They argued that from the very beginning, all the documents pointed to one thing and one thing only, a variance. And the timeline they presented is pretty darn compelling. First, Lot 19's own architect sends a letter that explicitly asks for variances. Then, the HOA committee approves meeting minutes that use that exact same word. And to top it all off, the HOA's own lawyer sends a letter that also uses the word variance. Each document is like another brick in the wall of their argument. During his testimony, Terry Marvin pointed this out directly. He basically said, look, when the committee had a chance to correct the official record, those meeting minutes, they didn't. They approved them as written, variances and all. And this right here, this is probably what the petitioners saw as the smoking gun. This is a direct quote from a letter sent by the HOA's own legal counsel. It doesn't get much clearer than that. It explicitly says a variance was granted and would not be taken back. For the petitioners, this had to feel like case closed. So, with such a clear paper trail, this seems like an open and shut case, right? But this is where the story takes a pretty dramatic turn. So, what did the HOA have to say for themselves? At this point, you'd think the argument is over. The documents consistently use the word variance, which requires a much stricter approval process, one that, was never followed. But here's the twist. The HOA's consulting architect, Jerry Young, who had been with Stone Canyon since it was founded back in 1999, took the stand and offered a completely different explanation. And there is the core of the defense. Young testified that his repeated use of the word variance in official communications was simply a misspeak, a mistaken terminology. So the HOA's full argument was this: the word variance was used by mistake. What the committee actually discussed and voted on was a modification, which was the correct and much less strict procedure for secondary stuff like driveways and site walls, all allowed under a 2019 rule change. So, while the lawyers and architects are arguing over semantics, what did all this actually mean for the people living right next door?
let's shift our focus to the tangible, real-world impact of this decision.
For Terry Marvin and Lori Lefferts, this was not some academic debate. They argued the approved construction would directly and negatively affect their home, their peace, and their financial investment.
During his testimony, Marvin, who happens to have a background in real estate law and investment, actually put a number on it. He suggested that the changes next door could slash his property's value by as much as 8 to 10%.
So here's a quick summary of their concerns. Their tranquil patio view would now look onto their neighbor's driveway. They would face double the noise from 2 AC units right outside their bedroom. And twice a week, they'd have to listen to garbage bins being rolled down that new driveway, all of which they argued would make their home much, much harder to sell in the future. And in the end, it all comes down to this. Do you trust the written record, the paper trail that repeatedly says variance, or do you believe it was all just a simple misspeak? It's a fascinating case, and it's a powerful reminder for anyone living under an HOA. The rules are only as strong as the words they're written in. And sometimes, the meaning of a single word can change everything: your view, your peace, and the value of your home.